Good morning, everybody. My name is Bill Sharp, and I'm with Sharp Kemm, as you can see, and we're going to talk about the Offshore Voluntary Disclosure Program today. But the topic is really broader than that today, I must say, and we'll keep this very informal because we have a small, intimate crowd. But it's really more about just not the Offshore Voluntary Disclosure Program, but it's also about just navigating around offshore tax hazards. Because whether you're helping a bona fide, fully compliant international investor staying abreast with and in compliance with the law, or you're helping someone get out of deep yogurt because of prior sins, either way, we've got a lot of rules to navigate around. I was actually hopeful today that I'd have a new piece that I've just authored that's publishing in Lee's publication, in fact, Tax Notes International. This comes out next Monday. This is proof of the, you can get a shot of it, guys. This is proof of the galley. It went to Doug Smith and Kathy Phillips yesterday. And it's about an 11-page article on how do we navigate these hazards. There's certainly a confluence of different events going on here. And we're going to discuss those today in a very informal setting, but we're also going to focus on practical and technical aspects too, to give you kind of a full shot of what's happening in the offshore world and what you can do to navigate around those hazards and maximize the opportunities. That's kind of the cup of tea here today. But let's move on into the further comments on the introduction. There's no question that the U.S. government is aggressively enhancing its efforts to eradicate offshore tax abuse and dismantle bank secrecy. But the yin and the yang here, the flip side of that is the U.S. is also seeking for compliant American abroad and also compliant non-American inbound to the U.S. to further enhance its regulation, disclosure, reporting, and really taxation of those properly reported transactions. We see that across the board. And it's clearly a cooperative undertaking involving a cross-border bilateral and multilateral effort. We see that in many sectors. But we've got to take a step back and ask ourselves, what are the key drivers here? What's driving all this? Because 10 years ago, someone would come into the office and say, gee, do I need to worry about this Cayman account? And of course, we would not advise them not to become compliant. But if they walked away and didn't become compliant, chances are they weren't in too bad a shape, although it was 10 years plus ago that we had the new Tax Information Exchange Agreement entered into between Grand Cayman and the Cayman Islands and the U.S. in actually November of 2001, just after 9/11. But anyway, there's a cooperative effort going on, and we see that even in some private sector, public sector organizations. But what are the key drivers? Because there are a lot of, it's just not OVDP. We hear about OVDP all the time, but it's a confluence of many, many factors, including, of course, FATCA. We've all heard about FATCA. We're sick of FATCA. We're tired of hearing about FATCA. And many of us thought FATCA would not actually come to fruition. But actually it has come to fruition, slipped into Congress in March of 2010, no hearings, no real debate, no markups. It just kind of slipped in as an attachment to some bill, some archaic, important bill back in 2010, March. And it is becoming effective January 1st, 2014, as many of you have read. So we have FATCA as a major driver. And in fact, in one case, and I'm a little nomadic because under my Swiss visa, I spend about a third of my year in Switzerland, a third on the West Coast, and a third on the Florida coast. And we have an office in San Francisco as well, and I have a home there. But the real driver we're hearing now, and this is from the streets of Zurich, is that some banks today are saying, we're going to start disclosing in June or July. And I'm taking a step back and wait a minute. You've got to worry about Swiss law. You just can't give away American customer details to the U.S. government without going through a certain process, and we'll talk about that more. But clearly, the banks and the fiduciaries in the Swiss and Liechtenstein terrains are not yet ready for FATCA. Some of them are getting ready, but it's going to happen January 1st, 2014. Just like we all thought the millennium might not happen. Remember those days? All your data's going to crash and the world's going to end, this sort of thing. But really, FATCA is going to happen. Now, in addition, another key driver is what I call this in perpetuity, series of offshore voluntary disclosure formal programs. Now, people said this is the third one we have in 2012. We have one in 11 and 9, but that's not correct. We actually had one OVIC in 2003. Okay, we had the 2003 program. Only about 1,000 people came in on that program. Under the current vintages, the 09, 11, and 12 program, we have about 39,000 people coming in, generating in excess of $6 billion of collections. Not too bad of a payday. And believe me, this has become an institutionalized effort of the IRS and DOJ. And we'll comment further why it's probably not in perpetuity, but it will go on for a long time because there have been major campuses established in Philadelphia and Austin. There are major opt-out centers, and we'll talk about opting out today, being established in other key markets from Milwaukee to Kansas City to Southern California. And those pockets of expertise, these are buildings with people, with leases. I mean, they're not going to go away tomorrow. There's a definite parallel between FATCA and the 2012 OVDP. They're kind of riding together. So look to OVDP. This is my prediction, crystal ball, probably wrong, but OVDP will probably be around until at least 2016-17 as FATCA comes into the realm. Okay? And by the way, FATCA just alone in Switzerland will affect at least 200 to 300 banks, as we've been reading about, both the Tier 1, Tier 2, and potentially Tier 3 banks. But we won't get too bogged down in it. We're still in the introduction. So continuing on in the introduction, and again, these are the drivers. We still have the so-called quiet program, and the quiet program is an ability to become compliant, not through the formal program, but through the IRS voluntary disclosure practice, and we'll talk about that. Another key driver is the recently formalized streamlined programs. We have about 7 million Americans living abroad. Many of them don't file. There are less than 1 million FBARs filed every year, and we're going to talk about this program and how important it is and how successful it's been to date so far. We've gotten a lot of informal scoop from some of our contacts with the government to illustrate how important this streamlined compliance program is. And then also we have a number of key domestic and foreign law and regulatory developments. From Luxembourg to Austria to the US to Treasury, we're seeing many developments that are all going toward attacking bank secrecy, making the world more flat and more transparent. And we're also seeing a continuing steady drip of proactive attacks by both the US and many partnering governments. We see the DOJ very active. We see the French, German tax authorities, the UK tax authorities with its list initiative. This is not going away tomorrow. And in particular, under the DOJ side, we see, of course, grand jury subpoenas and John Doe summons. We have one filed just on the West Coast implicating one of the Caribbean-based banks, First Caribbean, just recently. And we're also seeing, which I thought I'd never live to see, really new and improved cross-border detection activities. We're going to talk about these a little more too as we get into the details of these drivers, but there's no question that they're getting really good at this stuff. It's quite impressive, actually. And I'll give you some illustrations later on. But let's go back to the 2012 OVDP and talk about what we see going on. And we're going to run through these pretty quickly, but this was announced in January 2012. And in a nutshell, what it does is it enables non-compliant American taxpayers. And remember, American taxpayer means somebody having that blue passport, but also a green card holder or a substantial presence residence. Don't forget that. And it includes dual nationals. If it's a U.S. citizen with a non-U.S. passport, they're stuck too. That's always amazing when you meet with a client who doesn't speak English, has a Chinese passport, and indicates that, wow, I never even knew I was supposed to do this just because I have a green card. And that's another whole story in and of itself. A whole kind of focus on Asia vis-a-vis the U.S. regulatory and compliance initiatives. But anyway, it enables a client, a non-compliant taxpayer, to come in from the cold to effectively absolve any criminal tax issues and also settle the civil side of any prior infractions. And along these lines, we want to talk about what this means. And for the current program, we're going to be filing amended tax returns for the prior 8 taxable years. And it's a rolling 8 years. There's no prescriptive fixed year. It's going to be a rolling 8 years. So now we're starting in 2004, going forward through 2011, depending on when you filed your return. And those accurate, truthful, and complete amended filings, remember, they must be accurate, truthful, and complete. They cannot be half-baked. And we've inherited a lot of cases over the years where they were half-baked, and it creates all sorts of problems. But it's based on the reconstruction of all unreported foreign activities. And I call this reconstruction because some of the cases that we've inherited over the years, it's not a matter of dropping estimated numbers in amended returns. It's not a matter of taking foreign filed returns and using those numbers. It's a matter of actually taking raw foreign financial data and just not statements of assets, which is the normal monthly statement we obtain from our broker, but also the account statements, which is like the general ledger. I'll get a little granular here because I want to illustrate this point. But your account statements, your detailed debit and credit advices, your transactional detail, all that needs to be taken into account and identify, analyze, and document every category of gross income, every category of deductions, and any applicable credits, especially foreign tax credits. And of course then, since 2009, the ill-fated PFIC. Now we must deal with PFIC in the context of OVDP and voluntary disclosures. Before that, the service would say, it's too complicated, just drop the numbers in, give us your best. but now we do have the mark-to-market regime for PFIC. And for those of you who don't know, and I don't want to get too granular here, the passive foreign investment company known as PFIC is a tax nightmare, as we say, but it's manageable. Now, the big penalty. This is one thing that really I've railed on in a number of articles that I've written, mostly with TNI, I might add, but this is the 27.5% penalty if your client had $1 million as a high water mark over the past 8 years. The penalty automatically is going to be $275,500, period. There are certain exceptions to this penalty rule. They're very, very limited. But again, this is an in lieu of penalty. It replaces all other reporting penalties, such as the FBAR penalty, up to 50% of the high water mark for every year for 6 years. We'll talk more about that. But it is in lieu of. But it does, and as I mentioned, it's reduced to certain percentages given if you've an inherited account and met a 4-condition test, or if it's a small account, there are conditions. But the whole point here is that it's very, very difficult to navigate around this penalty. And I like to call it, and my friends at the IRS don't like to hear this, we had a conference here in January, the 31st, I think it was, Annual International Tax Institute, and we had a great panel from IRS, and they like to think of the penalty as being malleable and fitting a lot of sizes, but I've written and still call it a one-size-fits-all penalty in lieu of penalty. Now, the only advantage I would say is that the OVDP does provide for some degree of certainty in its so-called package terms. And it basically says, look, if you come in here and comply with the rules, even though this root canal surgery is going to take 1 to 2 years, and even though it's going to be a bureaucratic train stop with at least 3 major stops, and even though we're going to shower you with computer-generated notices from the campus and a lot of interaction with your agent group manager and maybe even the technical services committee and possibly IRS counsel, and again, even though this may take 2 years, we're still going to call you this, we're going to give you the certainty of these terms. And the certainty is basically a walk from criminal or criminal clearance letter. The certainty also includes that 8-year period. Remember, we have open statute issues when we're dealing with offshore noncompliance. It also includes the mark-to-market regime for PFICs. Just one, I'm going to become a little granular here for a minute, but think of a case of a defective foreign trust. It's a non-grantor foreign trust, and the only beneficiary is a U.S. person. And it's accumulated money for 30 years, let's say. As you know, under the throwback and accumulated distribution rules under the U.S. law, even though that trust, which has gone from $1 million to $5 million, let's say, and is ready to distribute to the U.S. citizen, most of that money's gone because of the accumulated distribution throwback penalty rules. I won't go into the granularity of what that means, but it's a huge penalty for the accumulation of money in an offshore trust for the benefit of U.S. beneficiaries. One strategy to avoid that 100% forfeiture is to go into OVDP and end up engaging in what we call signing a statement of dissolved entities, taking the 27.5% penalty on the $5 million, and avoiding the $5 million forfeiture. But I can come back to that later. I don't want to get too detailed as we kind of transition through this. But we do have the certainty of the package terms, which are essentially a criminal walk and a settlement of all civil terms, including the penalties. And now the question again, how long will this continue? It will not go in perpetuity. It won't go on forever. In this most recent article, which is coming out on Monday, I've advocated that it should be put in place permanently. Listen, why would you invest in all these campuses in Austin, Philadelphia, all over the country, Florida, Southern California, and not have some degree of commitment here, or at least put it on a 5-year term renewable to give some certainty? Because we're spending a lot of money on this. It's a big investment. Why not amortize that investment with certainty of the program being available? But we'll see how that goes. But it will go likely for a number of years, including the transition of FATCA into law. Let me flip here. And as I mentioned, FATCA transitions to law. That's going to be a driver for OVDP to stay in place. In addition, I guess this was the day before yesterday, the GOA released a study, and they took 30 sample cases. This was kind of cool. They took 30 large sample cases and said, where's most of the problem lie? Where are the big problem areas? And of course, Switzerland ranked, I think it was 24 out of 30 cases. And then the other countries mentioned here all had significant relationships to noncompliance. And you can see those countries could be coming online down the future. We've seen a lot, well, historically out of the Caribbean, many times over the years, a lot out of Israel, a fair amount out of China, a great deal out of Luxembourg. Those are fairly prominent offshore targets of the U.S. government. Now let's move on to quiet filings. This is always kind of interesting to me. What's a quiet filing? You know, for a while, the IRS said, we really don't like these. They're not very good. And fortunately, the OVDP addresses And it does pick up on language in the 09 and 11 programs, but a quiet filing in a nutshell is where instead of going to the formal OVDP and subjecting yourself to the automatic 27.5% penalty, footnote, there may be ways of avoiding that, we'll go to that later on, but the 2-year, 1.5-year rigor of the OVDP, we go into the quiet program. And what that means essentially is that we've done all of our homework we do in an OVDP case. In other words, we've obtained all documents, identified all issues, done all reconstruction, painted the fresh, clean picture for the past 6 years, not 8, and we go ahead and we file in with the service center. And one thing that's helpful to us is the FAQs have recently clarified that the IRS voluntary disclosure practice may still be a valid voluntary disclosure. But the point is, if you pursue, and here's the big issue, the zillion-dollar question is, do you go in the formal OVDP, or should you just file remedially under the voluntary disclosure practice? And you've got to look at cost-benefit critical analysis. And this is where the rubber meets the road. Determining whether to file formally in the program or informally in the practice takes a lot of judgment. I won't take the time today, but it's discussed at length in this article. But one of the key components is, what is the level of willfulness? In other words, did the taxpayer intentionally disregard and voluntarily disregard a known legal duty by failing to file FBARs, by failing to file 5471s or other information reporting forms, or pick up offshore income? And where there's a lack of willfulness or near absence of willfulness, we may be in a position to go through the practice, because why go through the entire formal program, spend a year and a half, 2 years, and get to something called the opt-out, which we'll talk about in a few minutes, end up in exam and have the same position as if you filed initially as a practice filing, picked up for exam and resolved there. And we're going to talk about that nuance further in a few minutes. But again, common examples are when we have an absence of criminal elements and a lack of willfulness, just a lack of willfulness. And I would just caution practitioners, discussed a lot again in the new article coming out next week, is this is where you cannot make a snap judgment. It takes a lot of insight and development. Clients always want to have the quick answer fast. And one of our sayings is, first of all, we don't want to frighten clients, we want to enlighten them, but also many times we have to save clients from themselves. And clients who are eager to go into a quick program fix need to do the homework first. Absolutely need to do the homework first. And along those lines, just in terms of client management, going into the formal program, it's crucial to say up front, we're going to have about a 1.5, 2 year train ride here. This is going to take a long time. And clients need to be aware of that going in, because it's not an easy fix. Okay, now let's talk a little more about declinations. This is when we filed in for the formal voluntary disclosure program and we've been declined. This is a hazard we have in every case we file in, because, and here's crucial, sometimes the case will come in and we'll see obvious offshore defects. It's better to file sooner than later. The longer you wait, the more likely you might have a timeliness problem, because the bedrock of voluntary disclosure is going into the government before they come to you or are aware of you, okay? So the initial pre-clearance is submitted and the taxpayers decline. I put 1 in 100, if not more. We rarely see declinations. We've seen maybe a dozen or so since 2008, maybe a dozen and a half. And when that declination occurs, as we always talk to our clients going in, well, what if I'm declined? Well, you're declined. But it's better to have been declined than not filed at all. That's the feedback we've had after now almost 5 years of this, since the July 1st, 2008 UBS AG summons was issued, almost 5 years. And we see those cases do have the high ground. There's a recent case called Curran that you've read about in the papers, where a lady did file in under the OVDP back in 2009, but she was unfortunately on the February 2009 UBS AG turn-in list. To make a long story short, Judge Reissuance eventually said, look, why are we even here in court? I'm going to grant probation and I'm going to cancel it. You're a free woman. She was almost 80 years old. And she had filed for OVDP. And we had cases like that, some still working out with the UBS AG, Epic, and other cases. So in our view, if you file involuntarily, you should get credit for that, as so far as the criminal justice system is concerned. But let's go a little further. Let's say if you received a pre-clearance letter. Let me just take a step back. When we file for OVDP, there are 3 main steps. First, your pre-clearance. You file in some basic data saying, here's the client, here's the social, here's the date of birth. Tell me if I'm pre-cleared and okay to go in. And in 2 weeks, typically, Philadelphia comes back and says, yeah, you're good to go. We've done a database check. Great. Within 45 days of that date, we had to file a more extensive offshore voluntary disclosures, plural letter, which is like a mini brief document kind of telling the story. And Philadelphia then takes a much harder look at the case, and typically within a month or so after that, we get an IRS clearance letter, the second stop. Then finally the case goes to civil, and we work it out civilly. So that's the third step. But here, if we received our pre-clearance, okay, when we entered OVDP, but let's say after we got our filing, after we filed our voluntary disclosures letter, and before we got a criminal clearance, or even after we got the criminal clearance, but before 906, that means the closing agreement, before we had our closing agreement, the case is declined. Believe it or not, and I've been doing this a long time, this is now happening. You may have read about it in the Bank Lumi cases. We've had it in other bank relationship cases, unfortunately, on some other cases where we had our clearance, our pre-clearance letter, we had filed our OVDL, we're in the process of getting our clearance letter, and the government said, too bad, we're not going to allow you in. And which is amazing, because it's coming to my web, says a spider, and after coming in under these pretenses, you wonder, wow, I should be safe, right? Well, the hazards here, which is pretty interesting, is that the IRS is basically saying, even though we've given you a pre-clear, and even though we've given you even a clearance letter, because you don't have a clearance, final closing agreement, we still are going to take input on a potential civil exam, a CID investigation, all the items listed here. Typically, in the cases we've been involved in, from what we can reconstruct, because the government really can't tell you this, but what we can reconstruct, it's probably agency-to-agency sharing of information, but we don't know for sure. You just don't know. So let's move a little more on declination of hazards. This is a major shift in policy, because, right, and this is not formal, and I've talked to friends at the IRS and saying, come on, don't say it ain't so. Come on. I mean, listen, we've come in and given you all the information. How can you now give us a declination letter? Our hope is these cases, and very few limited cases nationwide, we hope, will be worked out in the civil and not criminal arena, because it just doesn't seem fair. And again, why would this occur, and why after pre-clear or full clear? What we're told is it's basically due to information that came available from really 5 sources. We did get the 5 sources, which we won't go into here, but one representative did go through the 5 sources of how that could emerge after even a pre-clearance letter through some informal IRS feedback. Our view, and some of my fellow practitioners, this is unwarranted, and it does have the hint of bait and switch. Come on in, you're going to be safe, here's your pre-clearance. Give us your whole OVDL production. Tell us about every account number, who was involved, what happened, where'd the money come from? And then later on, oh, by the way, we think this is going to be declined. It's just unfair. So moving a bit further then, would such a case be referred by IRS CID or CI back to DOJ for prosecution? We hope not, and especially after the current case and the remarks of Judge Reissuance, we hope that's going to be the case. Now, let's go to a very tough topic. Let's go to opt-out or not opt-out, and let's talk about what that means. Opt-out means, look, we're in the formal program. We filed in, and, excuse me, what that, the predication for filing in is that practitioner had some concern about criminal exposure. So taking the safe route, we went into the voluntary disclosure program. We submitted our pre-clearance application. It was approved. We submitted our OVDL. We received our IRS-CI clearance letter. After that, we submitted the full civil package. Everything is computed, reconstructed. We know that we have a good set of 8 years of books and records, basically being the 8 years of reconstructed foreign financial related income that is now embedded in those amended returns. And everything's ready to go. We get our closing agreement, we make some tweaks to it. IRS, the case agent, group manager, everybody's happy. We're relatively happy. And the client says, yes, but I'm still going to pay 27.5% of $12.6 million. It doesn't seem fair when I just made some foot faults. It doesn't seem fair that I simply didn't understand how the FBAR rules worked. So the question is, if we elect to opt out, we no longer have the package terms, meaning that we don't have the protection, in theory, of the criminal walk, the 8 years of reconstructed federal income tax on those amended returns, and the cap of 27.5% penalty, as elicited here. Now, again, why would someone want to opt out? Well, remember, the 27.5% penalty is in lieu of all other penalties. And really what should be happening here, and this is a key driver of this whole opt-out, is before February 2011, we did have IRS discretion in the early cases under the 2009 March Voluntary Disclosure Program. Unfortunately, in February of 2011, that discretion was unilaterally revoked through a memorandum written by a senior IRS official in February, again, 2011. And only certain cases in the pipeline are entitled to reasonable cause or discretion treatment. And again, we are of the view that within OVDP, the government should be taking into account reasonable cause in trying to sort these cases out. Because, for example, let's take some examples. I told my CPA everything. You know, I told my CPA about my foreign financial accounts. I told him about X, Y, and Z. But I may not have told him about some nuances involved, that my brother was holding it for me. I mean, maybe there's something innocent involved. We don't know, and it's very treacherous to be superficial about facts. But let's say there was a pretty good case here of reasonable reliance. I mean, first of all, OVDP may not have been the right course of action. Maybe the IRS practice filing would have been better. But the point is that there may be a reasonable cause based on reliance of a professional advisor. Or that accidental citizen who does not meet the Streamlined program, as we'll talk about in a minute. You know, I was born in the U.S., moved to Switzerland at age 6 months, have been working in the philanthropy business my entire career, never knew I was supposed to do this, and my tax is too high for the Streamlined program, which, let's footnote that as we get to Streamlined in a few minutes. You know, I didn't intentionally disregard a known legal duty because I didn't know what an FBAR was. I've not even filed. I'm a non-filer. So those are two examples of how this could work out. So the question is, which way to go? Do we want to go OVDP, the formal program, and opt out later on? Or do we want to go through a qualified quiet filing? And by the way, on quiet filings, when we reconstruct and we send 6 years returns, don't do the staggered anymore. I mean, I debate this with fellow practitioners and even within our firm. But we're the view under the IRM, you don't need necessarily the full lawyer's letter on the front page of the filing, but mail it in one shot. Because by staggering it, it looks a little, maybe one's trying to make this a stealth filing, which may not be a qualified quiet filing. But in any event, this entire question here, the bottom line question of which way to go, that's the whole topic of professional judgment, of looking at all the facts, and I would commend all practitioners, that's a good 30 to 60 day review. It doesn't happen overnight. You've got to know exactly what is going on. And again, if you go to the FAQs, it talks about OVDP is designed for situations in which taxpayers have engaged in offshore abuse and evasion. I think that's FAQ 3. And when you have a client that has made some foot faults, and particularly computational foot faults, I didn't understand this was a PFIC. I didn't include this because it was exempt under Swiss law, and I didn't know it was taxable under U.S. law because it was primarily taxable in Switzerland. Or I sold my home in Israel, I held it for more than 4 years, it was exempt there. I thought the treaty protected it. These are all good non-willful sound bites. But again, the key is you've got to look at all those, assess the criminal risk, assess whether there's been any offshore abuse and or evasion, and how that would be viewed by the government. Now, let's move on to another topic. And this is going to be, let's see if I skipped over, let me back up a second. Okay, extending the statute of limitations. Here we go. And this is, everybody's familiar with an FBAR, I believe, the Foreign Bank Account Report, and that is the operative form in which we report foreign financial accounts more than $10,000 for the prior calendar year as it is due June 30 of the subsequent calendar year. And it typically has a 6-year statute of limitations. But here's the kicker. The IRS has recently came of the view that when we sign those FBAR consent forms for cases in voluntary disclosure or even under general exam, that we're in effect, we're waiving the statute of limitations defense. Now, everyone knows, and I'm going to jump ahead here comparing to Title 26, everyone knows under Title 26, even if you sign a Form 872, which signifies an extension of the statute, if the statute has already been blown, then in that case, you're going to be in a position to later say in a tax court proceeding or otherwise, look, the statute is gone, you're barred. It's the government's obligation to protect statutes, not the taxpayers. And what we find troubling is that this new apparent policy is being developed where there's no authority for it, and that's part of the problem. There's no authority saying you can't breathe new life into a dead statute under Title 31. And apparently we've been led to understand that there's some common law authority that would support this informal position that you can, in effect, breathe new life into a dead FBAR statute by signing this waiver. Legally, I find that dubious, but until we have some precedent, it's a big hazard. And again, the second large bullet point, unintended consequences. We always have to look at unintended results. This could cause a situation in which your client is on the verge of having the FBAR statute for the critical year blown to say, look, we're not going to sign it. Now, if you do that, you're going to be removed from OVDP, and you've got a way being removed from the safety of the package returns. What's going to happen then? Does that mean that we're going to end up in a far less advantageous position? I mean, where does that put us? So that's something to really think about. I hope the national office comes out and says, you know, we were saying this informally, but we really didn't mean it. You know, please say it ain't so. Now, let's go to the new Streamlined Compliance Program. I applaud the government. The IRS came up with this after a December 2011 announcement saying we're going to start dealing with Americans living abroad. I think, as I mentioned earlier, there are about 6.8 million Americans living abroad, according to the State Department. And this is going to be it is a wonderful program. And just a little backdrop, it was announced in December of 2011 quietly, and then on June 26th of last year, IRS in its FAQs and an announcement with FAQs said, by the way, this will be coming and it'll be effective on September 1st. And we kind of thought about that, September 1st, that's a Saturday, that's kind of weird. And sure enough, they said, we'll give you guidelines on how this works. And those guidelines came out on the eve of September 1st, literally at 5 o'clock in the afternoon Eastern time on Friday, August 31st. We thought that was very interesting. But again, if you're an eligible taxpayer, you're only required to file 3 years of delinquent tax returns. You're going to avoid the failure to file, failure to pay penalty, which can stack up to 47.5% of the tax due. And if you file your relevant information returns, including FBARs, for 6 years, you're going to walk away with no penalty. Just pay your tax and interest, and you're good to go. No penalties is emphasized here. Now, what's interesting, again, as I mentioned, there are a lot of Americans living abroad, but again, you can see only about 620,000 FBARs filed in 2011. But our supposition is that the other 5.9 or the other 6.2 million taxpayers have accounts under $10,000. I'm sure that's the answer. But this Streamlined program is very helpful because if you've been living outside of the U.S. since January 2001, and you must have been a non-filer. So it's kind of weird in a way. If you just disregarded it, you're going to qualify for this program. But if you tried in good faith to comply and you have problems, you're going to be an OVDP potentially. So it's a little ironic, the twist. But again, what's key here is the taxpayer being deemed a low level of compliance risk. That's essentially a 10 or 11 factor test. Did you have U.S. source income? Did you have U.S. activities? Were you structuring? Were you complying in your home country? And the kicker, though, is having a tax, and here are some of those items listed. The kicker, however, is having no tax in excess of $1,500 for each of the 3 look-back years. Now, a couple of wrinkles here before we go to the next slide is, as of August 31st, 2012, there are already several hundred, and this is unofficial feedback we heard, over several hundred cases already lobbed into the Austin Service Center on Streamline. We've learned since then, just through unofficial chatter, that it's probably several thousands of cases that have been filed in because it's very, very attractive. I mean, look, OVDP with 8 years back, a negligence penalty, actually related penalty, plus that 27.5% one-size-fits-all penalty, or 3 years back, tax and interest, no penalty. It's a pretty good deal if you qualify. Now, but here's where the rubber meets the road, is for taxpayers who present a low level of compliance risk, then we're not going to have any penalties or any follow-up reviews. And again, that's the 11-factor test, including 1,500 or under. We've advocated in many cases, look, if it's 8,000 per year, treat it as 1,500. If it's 15,000, 44,000, if you're good to go on the other factors, why would you be penalized just because financially you didn't get a foreign tax credit due to 904 limitations or whatever the case may be? Another key point is that if taxpayers are determined to be a high level of risk, well, that's a long slide, it should be more brief, but I'll cut through the chase here and get to it, is that if you don't satisfy those 11 factors and you're deemed a high level of risk, then there may be a longer period of review and more penalty exposure. Not good. So, and what's very important as we go into the Streamlined program is it's a fork in the road, because if you choose Streamlined, you then can't backdoor into OVDP. And if you go into OVDP, contrary to what we were advocating and just corrected in these galleys last week, you cannot later then migrate back into Streamline unless you were accepted by the service in OVDP on or before Yes, August 31st, 2012. So if you're in the pipeline when the program was adopted, that is, you're already accepted in OVDP, you can now migrate back into Streamline. So just repeat, you go into Streamline, OVDP is a closed door. So that means if you've got some criminal concerns and it comes out on the examination because you're a higher risk taxpayer, that could come out and could come back to really be a problem. If on the other hand you go into OVDP and you end up with some very low grade taxes owed and you satisfy most of the 11 factors, you got to say to yourself, wow, why do we do this? So one of the focuses we are emphasizing in the firm and a lot of our colleagues, practitioners, is on these cases where there's a low level of criminal exposure and you're looking at Streamline versus OVDP or a practice filing, really take that 30 to 60 days to evaluate the case closely to make sure you're not going to be stepping into the wrong trapdoor. Okay, let's move on now to some recent regulatory developments. We're going to go beyond OVDP because all this ties into OVDP. Everybody's been busy. We have new regulations that deal with passport matching. We have new regulations that deal with U.S. account interest reporting to foreign governments. And let's move on to the next slide. And this is a very important development. I always like looking at history, and I'll just flip through this quickly because we're running a little short on time. We'll go a little bit over time because we started a little bit late. But let me back up here. There we go. Yeah, these regulations were first published in 1992. And what these regulations say is that, look, State Department and IRS, start comparing notes. When an American applies for a passport or renews a passport, or when we have a green card, let's match it up with tax records and see if we're getting a fair share. Are they filing returns? How do those returns look? This came into play in 1992, the first regs. They sat dormant for almost 20 years. We have now, however, reissued proposed regulations, and they are only looking at applicants with passports, and only basic information is required on this matchup, but it's enough to get into the full tax picture, the tax modules. And what we're really emphasizing is that if you're a non-compliant American living abroad, this is a real hazard. If we're doing a lot of work out of Hong Kong, for example, one of the countries we talked about earlier, with individuals who have U.S. passports that have perhaps a Canadian passport as well and a Hong Kong immigrant status. And those are high risk because we're worried that although this is still a proposed reg, it's going to happen sooner than later. Now let's go on to we're going to move over this pretty quickly because I want to save some time for some additional topics. These are the non-resident alien deposit interest reporting. With Canada, as you all know, the U.S. shares information automatically with Canada regarding bank deposit information. I call this kind of reverse FATCA because what we're doing here is we're allowing the U.S. to help its counterparts abroad combat tax evasion. It really is I think in the spirit of FATCA, these regulations came to play, and it would apply globally, by the way, just not to a treaty partner necessarily, but there are limitations where the U.S. government is not going to share bank information to a foreign country that does not maintain adequate confidentiality protections to protect the on-lending of this information to jeopardize citizens or residents of that country. And certain countries, however, will be subject to automatic exchange, others by specific requests, and other countries probably not even allowed to receive the information because of local law confidentiality concerns. We will have a revenue procedure coming out with the IRS basically saying that these countries have good enough exchange agreements with us to merit automatic. It's going to be kind of the IRS scorecard or report card on what countries we can trust and countries we can't trust. So I think it's going to be very interesting to see what comes out of all of that. Now, a big topic. Again, all these drivers converging on offshore compliance, FATCA, the DOJ, treaty developments, and I call it converging compelled disclosures. Okay, FATCA, observations of the next move. This is old news. We won't go into too much here, but January 1, 2014, it's happening. What really surprises me, though, I must say, is that and this is, again, just spending a good chunk of my year in Zurich every year, is that so many on the implementation of FATCA through the intergovernment agreement, we have the Model 1 and 2, with which I'm sure you're all familiar, not a lot's been done. I mean, the big banks are working on this, but the X 100 other mid-sized banks, trust companies are at issue as well. So not a lot has been done. So for example, under the Swiss Model 2 Intergovernment Agency Agreement, I don't know if, real quick primer on this, because we are a little short on time, but a Model 1 agreement is a government-to-government agreement. So the U.S. government and the UK authorities team up in this agreement and everything kind of sorts through the UK government to satisfy the FATCA requirements. It's kind of like a one-stop shop. It's pretty neat, actually. Model 2 is US government with each individual Swiss bank. Now, why is that? Well, first of all, I became a real student of Swiss history because of, I guess, time on the ground, but really enjoying Switzerland. But remember, Switzerland is the oldest democracy in the world, except for the US, 1789 US. It's the oldest democracy in the world, but for uninterrupted, the US is the oldest in 1789. Because the US had 2 years where Napoleon took over the country, didn't like it, was too cold, and gave it back to the Swiss. True story. So they've been around for hundreds of years in a democratic format, but it's a confederation. It's kind of like how the US would have looked if we had had a reverse in the American Civil War. It's a true confederation with great powers in the states, or we call them cantons. And so under Swiss law, it is improper for a bank to share information to the federal government because that violates notions of Swiss bank secrecy. So what happens now is we've got a Model 2 agreement that the US and Swiss we've agreed upon, but what happens next? The Swiss have got to implement this through the Swiss Parliament. That's not a slam dunk. The good money says this Parliament will pass it because they want this over. Remember, the Swiss, for those of you who spend time there, it's a beleaguered place in the sense that they're just tired. They've been in this battle for 5 years. It's almost going as long as Afghanistan and with the US government. And they really want it over. They want a global settlement. That's another topic. But assuming the Swiss Parliament passes the Model 2 Intergovernment Agency Agreement, then will there be a referendum? Unlike the US and Switzerland, if you have 50,000 citizens sign a petition, then you must have a national referendum. It's how the people kind of keep a check on the government officials. There's a lot of accountability. So anyway, then what we have then is compliance pressure on US customers of foreign banks, particularly Switzerland, but other countries as well. Now let's do a quick cover over to our friends at the DOJ with IRS support, continuing enforcement actions. As you may have read about a couple months ago, the DOJ informally asked 21 Liechtenstein fiduciaries to provide data. My impression is that because there wasn't an official request tendered on April 30, which was the last day that the U.S. could have tendered that request to get the reach back to 2001 under some modified Liechtenstein legislation, I have the impression that the 21 fiduciaries pretty much provided the information that the U.S. wanted, and it principally related to just not UBS, but other Swiss taxpayers holding Swiss banks through Liechtenstein. Other current events, the John Doe summons, we see the new one out here out west, which is interesting. Moving on to the next continuing trend here, let's go back to the Liechtenstein request. We talked about the 21 requests. Again, that you may recall last summer, the DOJ sent an official request under the Tax Information Exchange Agreement with Liechtenstein, focus on Liechtenstein Landesbank. That's being resolved, I guess, from the bank, from the U.S. government side. Most of those cases have been adjudicated by the Liechtenstein Tax Authority and the Liechtenstein courts. But it's, again, a very important indication of what's happening in terms of global compliance. And then a couple more conclusory remarks, and then maybe we should have a couple of minutes for questions and answers. So hopefully I've covered it all so there are no questions. But anyway, what we're seeing here is an elimination of offshore abuse through a confluence of all these drivers, as I call them. It's just not voluntary disclosure. But the big concern I have, and I'm going to go back to this to highlight it, is really respecting the legal rights of affected taxpayers. And one of the things I jotted down on my comment sheet, if I can find it, is the whole notion of errant, what I would call improperly targeted citizens. I mean, think about an American working abroad, discharging duties as a managing director of a good-sized business organization with signatures on appropriate foreign accounts where the host business is in a country that has great geopolitical concerns. Think Serbia, think Syria, whatever you wish to think. And okay, there's a grand jury subpoena that's issued because part of the francs were traded into dollars, and part of that occurred in Stamford, Connecticut. And who's executing these orders is this American citizen, suddenly the target of a grand jury subpoena. So many times we're seeing, again, in the cases like this, it should be easy to sort out, well, not easy, but manageable to sort out that this is not a target, not only a subject, and certainly, if anything, a witness. And really nothing to do with the U.S. It's a non-resident-owned company operating abroad with an American working in its ranks. But this is why it's very, very important to assure the legal rights of affected taxpayers. In the opt-out arena, too, we've gone through voluntary disclosure. We're going to go through opt-out. When we opt out, and I don't want to get too granular here, but we're going to go through an IRS exam and then IRS appeals. But after appeals, there is no prepayment judicial form. There is no ticket to the tax court on these penalties, these information penalties. So again, let's make sure we have a fair playing field for resolution of these income and reporting issues. And hopefully, as will be reported, this will be upsetting to some of my colleagues in the government, but we really need for some policy changes on this FBAR statute issue, on this lack of reasonable discretion in voluntary disclosure, together with some of the other points I made, to make sure that we have some degree of fairness and equity, not only holding up constitutional considerations. One of my good friends, a lawyer out west, always raises the Eighth Amendment constitutional argument. Steve Tosher, many of you know him, about, are these FBAR penalties? He just wrote a good article, too, on this topic, or related topic on FBAR penalties and willfulness. But are these penalties reasonable within a constitutional context? I mean, when you have a 50% penalty on a $40 million account, when there's a questionable degree of willfulness, is that a constitutionally appropriate penalty? Well, with that rosy word, I'll go ahead and say thank you very much, and would love to have any questions or comments on this interesting topic. Thanks. Any questions?